Well, Wendy is with us in studio today, and we're going to be circling back to a story we covered about a fortnight ago of the dodgy car bought from Cape SUV. The unfortunate buyer spent more money fighting for justice than the vehicle was even worth. And the National Consumer Commission is going to respond to some of the criticisms made of its handling of this case and other car-related complaints during that conversation 2 weeks ago. I hope we'll have a little bit of time left at the end to share another listener's online shopping fail. Unfortunately, it's one we can't do awfully much to help with, but I think it serves as another warning to others not to fall for the same scam. So I hope we'll have time to get to that. And just a reminder, if you would like to join the conversation at any point, the WhatsApp line is 072 567 1567. Now, let's start with just a quick reminder of the context for today's show. It was 2 weeks ago, we brought you the story of Alison, who was sold a problematic car by a local dealership. This was back in June 2019. It was shuddering and giving a very uneven drive almost from day one, from the day she drove it off the dealership floor. It went in for multiple repairs, but when the gearbox failed 3 months after purchase, she was told it was her own bad driving which was causing the issue and was refused the refund she was asking for. And it was at that point that Alison sought legal help, and the matter ended up going all the way to the Western Cape High Court. Last month, that court found in Alison's favour. It ordered the dealership Cape SUV to take back that dud Daihatsu Terios. Lawyer Trudy Brookman, who represented Alison in her fight, told us 2 weeks ago how they finally got that outcome, and also shared a number of frustrations around the timeline, the pace at which cases like this are dealt with by the National Consumer Commission. Wendy, we're revisiting this case today because the Commission feels it wasn't given full right of reply.
Yes, Pippa, and they are correct, I must say, straight away. Their spokesman responded to my email with I had put a lot of questions in it, and we shared those few paragraphs on air, but she didn't point out that she'd also given me additional, very detailed responses, but embedded within my original email query. They weren't, apart from one very far down in red, they weren't highlighted in any way. So I assumed that they were choosing, as sometimes people do, just to give a very brief response. So no malice at all in our failure to include them, but I understand how they came then back to us to say. But
You only shared the paragraph summary, not the detail.
We haven't had the full right of reply.
Okay, so we're happy to correct that today. Yeah. You wanted to start with a short recap of the handling of this case.
Okay, so when that gearbox failed in September of 2019, 5 years ago, Alison did not accept the excuse that her driving was to blame. At that point, she asked via her attorney, Trudy Brookman, that the deal be cancelled and that the Terios be returned by her for a full refund of the purchase price that she'd paid. Cape SUV refused, which led Alison to lodging a complaint with the National Consumer Commission, which referred the case to the tribunal. And as she shared with us, there's a process here. So you can first go to the Motor Industry Ombud, and if they find in your favour and the company doesn't take any action, you then have to go via the National Consumer Commission. And they then have to refer to the tribunal because only the tribunal can make a ruling that is binding, like a court ruling on the company. Okay, so earlier this year, the tribunal sided with Alison, but the dealership appealed that ruling, which is how it ended up all the way in the High Court, and that ruling was handed down last month.
Okay, now just remind us the particular section or sections of the Consumer Protection Act which apply here.
Okay, it's Section 56, and I think it's Section 62, whatever, 56.2 says that if a supplier repairs goods or any other component of goods within 3 months, the defect has not been remedied, or there's a new problem, the supplier must refund the consumer. And it was on that basis that the tribunal ruled that the dealership must now collect the vehicle from Alison and refund her the 152,000 Rand purchase price within a month. That was in February, and as we've said, the dealership appealed the judgment, and that's how it landed up in the court. The court found in Alison's favour, dismissing the appeal with the comment that there was no doubt that the vehicle was defective from the start. Now, at the time of the judgment, the Commission claimed it as a victory for consumer rights and for the Commission's approach in handling such matters. But Alison emailed me afterwards to say that her own experience working through the commission had not been without its frustrations, describing poor communication, the fact that at one point her email address was captured incorrectly. So if it hadn't been for the fact that Trudy was also getting the correspondence, she wouldn't have known what was going on and when. Very slow response times, she said. If I hadn't appointed and paid for a lawyer to help me with this process, Alison said, I would have been totally excluded from any official correspondence. As a result, though, her legal fees outstripped what she was due as a refund for the car. She was not granted costs by the court, which wasn't at their discretion. If the case comes via the NCC, costs are not granted because technically you don't need legal representation. You get free legal representation.
By the NCC itself?
By the commission, yes.
Okay. Alison, though, did have legal representation, and her attorney, Trudy Brookman, told us in that interview 2 weeks ago her firm had assisted about 45 consumers over the years to submit disputes to the commission. And the staggering thing, she said, was that Alison's was the first that had actually been investigated. Is that correct?
Yeah, she said the others simply die there due to the claim prescribing, unless we demand a notice of non-referral and the consumer then self-refers the case to the tribunal. But you can't do that unless you have that notice of non-referral from the
commission saying we're not proceeding.
Yes.
Okay.
She also pointed out how the dealership had responded with a spurious report to the motor industry organization. So the dealership had responded with a spurious report by the motor industry organization blaming Mrs. Evans' driving style, that's Alison, for the defective gearbox. The commission did not see the need to produce a report of its own mechanic to refute this claim. So that's how her firm brought an application to join Alison as a party to the case before the tribunal. So
they effectively got Alison to bring the expert who refuted that. Is that right?
Yes. So Alison's expert said nonsense and went into very technical detail about how the wrong part was fitted, and that's why the car was shuddering, etc.
And that is the evidence on which the court ruling in the end found emphatically that's
and do you remember
in Alison's favour.
That lovely bit of detail where the judge actually took his own bakkie on the said stretch of road and confirmed that his bakkie handled it perfectly. So it wasn't about the road surface. I thought it was a lovely investment on the part
of right, I remember
the judiciary.
Judge Nathan Erasmus.
Yes.
Yeah. Okay, so just to as we said, so what we reflected last week was a response from the National Consumer Commission, which had been sent to Wendy. It was just the summary at the top. We didn't realise there was more to it embedded within. Wendy, won't you just recap for us, though, what that summary said?
The Commission said we should see this victory as a victory for the consumer and not for the NCC or Ms. Brookman. The NCC received a complaint from the consumer and not their attorney, investigated the complaint and referred it to the tribunal. It would be rather unfair to raise the hopes of a consumer and play with their emotions. Where the NCC does not see prospects of success, we close the matter and issue the consumer with a non-referral. So they're saying it's not so much that they didn't get round to dealing with the case, but that they didn't see prospects of success. The NCC investigated this matter, that would be Alison's case, as there were prospects of success. It is for this reason that the Commission did not rely on the experts' evidence, but relied on the CPA. Ours is to look at the facts provided by the consumer, the evidence verified through the investigation, and apply that to the provisions of the law. And that's what we reflected on this show 2 weeks ago.
Okay, and they then mailed us after that show to say that wasn't our full response that was reflected, and which then led Wendy to discover that there was in fact more to that. So what we've done is invited them to join us today to broaden this conversation. We've also invited consumer attorney Trudy Brookman to listen in and respond if necessary. And it's a great pleasure to have both of them with us on the line. I'm going to start, if I may. Joining us is the Commission's executive head, Prudence Moilwa. Prudence, thank you very much for making time to speak to us today. You're very welcome to the show.
Thank you very much. Good afternoon. Good afternoon to you both, and good afternoon to the listeners of your radio station.
Thanks, Prudence. Wendy, over
Hi,
to you.
Prudence. So first of all, apologies again from me for not realizing that that there was a lot of detail provided that I just simply didn't see. So let's start with the question of why it took so long to deal with this case. In terms of the main CPA complaint, normally it's the part of the law that you rely on is the product failed within 6 months. The consumer had a right to return it for their choice of a repair, refund, or replacement, and you took no responsibility. The written response that I got was that the right to return a defective product did not apply, as Alison's vehicle had been repaired about 3 times by the dealership in question at her election, meaning that was her choice. Where is that provided for in law, that once there have been attempts at a repair, you then that section of the that part of Section 56 that says, there is a defect, you must replace whatever. Why does that not apply? You're saying prescription isn't an issue because it didn't apply.
Okay, I think you're talking to 2 issues that are not related to one another. And I think I would like to maybe assist you as well as the listeners who are on the line. The Commission attempted to give you reasons why we do not issue notices of non-referral on request. And I think Trudy should know this, and I think for purposes of today, for all the listeners out there, as well as yourself, Wendy, is to bring you to the specific section that regulates the notices of non-referral. Section 72 of the Consumer Protection Act, when you read Section 72(1), I think it's B, it lists the circumstances under which the Commission, on assessment, can issue notices of non-referral. Number 1, I would like to clarify. We don't issue notices of non-referral on request, no matter how many times you request. The law does not say when an attorney or any other person demands or requests a non-referral, they will get it. The following 3 circumstances are outlined in Section 72 and our 72A, Roman figure 1 to 3. It says the Commission may issue notice of non-referral if a complaint is frivolous or vexatious, number 1. Number 2, when the facts, if they are true, they would not constitute a remedy in terms of the CPA or if a matter has prescribed. And I think that also should settle all this, the issue that Ms. Brookman kept on coming back to say that he requested non-referrals 18 times and we still have not complied. To maybe put this to rest, we only issue non-referrals under those circumstances. If a complaint is frivolous, and if the facts, even if they are true, would not have a remedy in terms of the CPA, and if the matter has prescribed. Now, those 3 circumstances did not present in this case. So in our attempt to then respond to that, it was then taken out of context to say that we refused to issue notice of non-referrals when we requested it 3 times. The second issue are the sections that you are referring to. I would also like to maybe say to the consumers out there, it would be important for consumers to start also engaging with the work of the National Consumer Tribunal. The judgment that we're talking to that was issued by the tribunal on the 22nd of August 2024, that judgment is, no, this one was for the Western Cape, sorry. The date of the judgment was the 1st of February 2024. I will give the case number to the producers so that consumers can read it for themselves. It's a very simple judgment. We investigated the matter, right? Mm-hmm. And in fact, we investigated the matter and did not issue a notice of non-referral because the grounds were not there for us to issue a notice of non-referral. We successfully investigated this matter, and the Commission, in its wisdom, decided to then file the matter with the tribunal. Our attorneys internally, who are very qualified, filed the matter with the National Consumer Tribunal and successfully argued that the consumer's rights were violated. The semantics between Section 56(3) and Section 56(2) really featured in the last segment. And I would like to explain it a little bit further. And it's a pity that when you do read this judgment, and I would advise consumers to also look at this judgment, very simple terms, it is written. The background that is given there is the complaint and all the factors that the National Consumer Tribunal took into consideration to come to the decision. The Commission argued that the rights of Alison were violated by the supplier. We argued successfully that the rights of the consumer were violated in that the vehicle itself was defective. Now, the semantic that was raised in your last interview was that we argued the wrong section, which is also not true. It's section 56. Irregardless of 52 or 51, it could have come to the same conclusion that the consumer's vehicle was defective. And I'll tell you the reason why we argued section 56.3. Because there were, repairs that had been performed here. And there was even reference to a specific case where a supplier has performed repairs on a vehicle, and there are further defects that are discovered. The section 56.3 can still be used to provide the consumer with the redress. Now, I'm saying we argued successfully because the tribunal agreed with the National Consumer Commission's case or presentation of the argument in terms of section 56.3, in that in this case, then the consumer, because of our argument, then was given and granted the judgment in her favor, in that the consumer would then be given the refund that he had paid, that we have rounded it up to 152,000. I think it was 151,000 odd rands that the consumer had paid, and the tribunal held that indeed the consumer is entitled to that. And after that, the supplier then took the matter on review. He took the matter on appeal and took the matter to the High Court, as you indicated in your opening remarks. The matter was heard by the High Court of South Africa, Western Cape Division, where in Unicity Trading had actually applied for the decision of the tribunal, the decision that was in agreement with our argument. The decision of the tribunal in this regard was that the consumer must be refunded on the basis that the supplier violated the provisions of the Consumer Protection Act, specifically Section 56.3. Now, when we got to the tribunal, and I think because Trudy is there, he will speak about why she decided to join the matter, and also called in an advocate that resulted in the consumer having all these costs that the consumer had now paid, because our services are for free. We are a public office established by law to provide free services to the consumers of South Africa. Wendy joined the matter as she should have, because it's within her right and her client to join the matter on the basis of the cost, which was not necessarily related to why we were appealing. We're defending the application that was lodged by the supplier on the basis that the decision of the tribunal that the consumer must be refunded. We vigorously defended this matter. We even got an advocate at our own cost to defend the decision of the National Consumer Tribunal that upheld the right of the consumer. In this regard, the Western Cape High Court, the Western Cape Division agreed with the tribunal, agreed that indeed the consumer must be given the 151,000 as a refund, which upheld the decision of the National Consumer Tribunal. So that I needed to just, give this linear approach to explaining the process that was followed. We investigated, took the matter to the tribunal, successfully argued it, won it on behalf of the consumer. It was appealed. We defended the matter at the Western Cape High Court, and we also won there.
I'd like to ask Trudy Brookman to respond to Prudence's comments. And Trudy, as you know, is the consumer attorney who represented Alison in this case. Prudence made the point before the break that the NCC is there to represent consumers, and you don't necessarily have to apply it to get your own attorney on board at your own cost. The NCC will fight a case on your behalf for free and appoints its own advocates, etc., as necessary. She did, though, say also that it is certainly your right to do so if you wish to have legal representation. And in this case, that was the wish of Alison, and that legal representation took the form of Trudy Brookman. Trudy, good to have you back on the show again. Thanks for making more time for us.
Anytime. Maybe I can jump in by just giving a tiny amount of good news. The dealership paid the 151,000 rand that is due to Alison on Monday. I was on leave then, so I picked up the payment this morning, and immediately after this interview, I've just received Alison's bank detail confirmation. I'll be paying it over to her.
That's
Great
very
timing.
good news. Fantastic.
Yes.
So
The
she's
matter
finally
is
got the money in her
resolved.
account.
And the car's been collected, has it?
Yes, the plan was that the car would be collected directly after the payment took place on Monday. It needs to be picked up by a flatbed truck, and I'm not sure whether that happened on Monday, yesterday, or will be happening today. I expect that may still be in the works, but
But it's in
the car
progress.
is there, as well as the separate gearbox, which had to be removed for the expert report to be drafted. So, all of that is getting resolved. With regard to Ms. Moyle was correct comments with regard to a notice of non-referral not being relevant in this case. Maybe I can just explain to the listeners what's going on there. So, in order to get your case heard, your dispute with a supplier heard by the National Consumer Tribunal, and for them to adjudicate on it and then create a judgment which you can then enforce, you need to, in terms of the Consumer Protection Act, first refer the matter to Ms. Moawa's organization, the National Consumer Commission. The Consumer Commission is intended to investigate it and then refer it on to the tribunal for hearing. The issue is that Peto, their public relations lady, said that they received 230 complaints related to second-hand motor vehicles per month. Those, over 90%, as far as I can tell, never investigated and don't make their way to the National Consumer Tribunal. And in order then for the consumer to get their matter before the tribunal, they need to get a notice of non-referral from the commission, and then they can self-refer to the tribunal. So that's the purpose of the exercise. But in this case, which in my experience is a minority instance, Alison's case was investigated and was referred to the National Consumer Tribunal, which is a win and something to be celebrated. It's exactly how the process should be working. What Alison's issues were that there was a delay in the investigation, which led to the prescription, in other words, the lapsing, the inability to be enforced of her claim under Section 56.2, and that 56.2 claim, if I can just explain, sorry about all the references to sections of the Act, let me tell you what it really says. Section 56.2 says that if you buy goods and within 6 months after you receive those goods, you discover that the goods are not fit for their purpose or are defective, then you return, as a consumer, return the goods to the supplier, and they must then refund you if that's your choice, or you can choose to have the vehicle or the other goods repaired. In Alison's case, that's your first remedy, that's your first benefit in terms of Section 56. The second one says, if you have gone back with your defective vehicle to the supplier and the supplier persuaded you that they would rather repair it, if another problem or the same problem comes up again within 3 months after the repair, then once again you can take the vehicle back to the supplier, and this time they can't repair it again. They either have to replace it or refund you. So in Alison's case, the 6 months from the time that she purchased the vehicle, that claim had already prescribed, in other words, lapsed, because a period of 3 years had passed after the time that she had purchased the vehicle and discovered the defect, reported that, and unfortunately that claim could then not be pursued before the National Consumer Tribunal. The other claim, which thankfully flew. The one was the one that pertains to the 3-month period after the repair of the vehicle, where a second problem then occurred, or in fact a third or fourth problem, actually, in the case of Alison's vehicle. That one thankfully made it all the way through the tribunal, was acknowledged there, and then that was confirmed by the Western Cape High Court on appeal. The issue with the appeal and the involvement of the National Consumer Commission, which is exactly what should be happening. The Commission should take part in the appeal proceedings, and they did. They did appoint an advocate, as Ms. Moa indicated. The problem was that the advocate or the legal team only submitted their heads of argument so late, a few days before the appeal hearing took place, and the judge in the case confronted the advocate about the lateness and the non-compliance with the rules of court with regard to the heads of argument, and the advocate couldn't offer a good excuse for that. One does need to comply with the rules of court, and as a result, unfortunately, the appeal from the NCC side, the National Consumer Commission side, relating to the fine that they had hoped would be imposed on the dealership was not heard by the court. So that's why one does need, in certain circumstances, to have your own legal team so that they can comply with the rules of court, get the arguments heard, etc., etc.
Trudy, thanks for that. I'm going to bring Prudence Moiloa back in at this point because you've raised a very important issue here, namely the capacity of the National Consumer Commission. Prudence, listening to that and that comment, particularly that the NCC receives about 230 complaints per month relating to second-hand motor vehicles, and just second-hand motor vehicles, that's excluding all the other complaints that you have to deal with. Is it perhaps fair to say that you have more cases than you can possibly handle, even if they all did have merits to proceed?
I will come to respond to what you said, but I think there's something that Judy said that requires a response. The issue of prescription never arose, and I would refer you, and I want to now speak to consumers, South African consumers. Please read the judgments on your own. They are written in very simple format. If you go to paragraph 20 of the judgment by the National Consumer Tribunal, you will see exactly why our case was successful. We argued the correct section, and nothing has prescribed, nothing about prescription. In fact, the argument of prescription was not successful when raised by the supplier, the National Consumer Tribunal. So I think it is a bit misleading to then say that there is something that had prescribed. The whole complaint had not prescribed. And the reason why I'm saying everybody listening here, please go to the judgment by the National Consumer Tribunal. It's a judgment of the 1st of February 2024. Go to paragraph 20, and I'd also advise Trudy to also read it again, because some of the issues that she's now raising are not issues that even appear on the judgment itself. And also go to the judgment by the Western Cape High Court. Some of the issues that he says we did not succeed on appeal are not issues that were not even raised on appeal. The issue about us seeking a fine against the supplier at the National Consumer Tribunal is that the tribunal did not agree with us that it was appropriate in this instance. The issue only of the fine against the supplier, but the main thing that we wanted was the consumer to get their money back. And I think the second issue was the conduct of the supplier to be declared prohibited conduct. And I think it's something that is worth a win. And I'm glad that today all of us do agree that this is a win for consumers in South Africa, that they can approach the institutions that have been set up to protect their rights, and that their rights will be protected. I can now come to the issue of capacity.
Thank you.
And yes, like all government entities, or even entities like ourselves, there is no point of saturation of how many complaints we can take at a time. And on a daily basis, consumers are coming to complain, as they should, against suppliers all over the country on different levels of things. We deal with all complaints except those that have been exempted from the Consumer Protection Act. So you can just imagine in terms of the complaints that come our way. However, the Commission is really doing its best. And I also wanted to emphasize, to address the insinuation that was made that the Commission is unable to attract staff that is qualified. Our legal division is capacitated with practicing attorneys who have been in practice before, and also emphasize that 80% of the matters presented before the tribunal in the last 4 years, we have received positive judgments for consumers, just to also deal with the issue of capacity. Now, the reality is that because there is no point of saturation, we do tend to get a lot of complaints that do not match our staff capabilities. And I think also to address the issue that was raised with regard to the particular complaint of Alison. And, I can say to this, just maybe in passing, to say it's part of my job not only to apologize to consumers on a daily basis on the matters that they would like to be dealt with in a speedy way, as they should. But the Commission really is trying to assist consumers in South Africa, even with the limited capacity that it has. And we do not just allow matters to prescribe. And yes, we also use our diaries, by the way, to time matters for prescription. In this particular issue, I don't need to remind everyone listening that we were hit with COVID-19 in 2020 as well as in 2029. And if you can recall, the lockdown started, I think, the beginning of 2020, and I think by November, momentarily the offices opened, and then in December we had to close again up until April, and then also, I think, for the most part, 2021, our services were disrupted. Not only that, but also the dealerships as well as service providers were not allowed to operate in terms of the Disaster Management Act. And I think those are some of the things that we need to take note of.
We're almost out of time, just a few minutes left in the hour, and I do want to wrap up our conversation with Prudence Moilwa, who is the Executive Head of the National Consumer Commission, and has joined us this afternoon to clarify some issues around the case we reported on 2 weeks ago of Alison Evans finally winning justice over the dodgy Daihatsu Terios that gave her so many issues. And wonderful to hear from her attorney, Trudy Brookman, that the money was paid on Monday of this week. So finally, the wheels of justice are actually rolling. Wendy, any last questions you'd like to put to Prudence?
Yes. Hello, Prudence. Just on the question of the professional technical assessment of these motor vehicles that form the basis of these disputes. So the dealerships generally have deep enough pockets for lawyers and also for to get expert to provide reports on, that will state, well, it was the car, it wasn't a defect, it was the driving style or whatever. Surely there would be merit then in these cases, which are very technical, to have access to its own teams of technical professionals who can provide reports that would head on challenge that the said dealership has provided, so that the judges, the tribunal have full information, technical information in front of them that lawyers would not necessarily have in order to come to the best decision.
Yes, if there is a technical point that is being raised with regard to the level of defect that is being found, fortunately in this case it did not arise. The supplier did raise the issue that when the case was going through the NIOSA process, there was an indication that the consumer's driving style might have affected the vehicle. But if you read the judgment, and I keep on saying read the judgment, that issue did not arise. There was never the technical point that was taken with regard to the vehicle and the arguments that were raised. We never at any point needed to have a technical expert in Alison's case. But there would be, obviously, in certain instances, like I wouldn't want to refer to the matter that is actually on my desk now, where we would then require technical expertise. In Alison's case, it did not arise because the technical point that was raised by the supplier was not even upheld by the National Consumer Tribunal. Okay. So at the tribunal, it was just the issues of the legal arguments that were before the National
Okay.
Consumer Tribunal. So, but in certain instances where the technicalities might affect the outcome, in fact, the tribunal might even require the parties to address them on a particular technical point. In this case, it did not arise.
Okay.
Thank you so much. We must leave it there. Prudence Moira, thank you so much for joining us this afternoon, Executive Head of the National Consumer Commission. And Trudy Brookman, to you as well, thank you so much for your time. Thanks. Sorry, Trudy. And the time has just run away from us. Wendy, thank you very much for the follow-up on this case. And Trudy, thank you for the good news of the thing that matters most, that the customer who was out of pocket for a car she couldn't drive has had that money restored to
yes,
her.
it's a victory, as everyone keeps saying, so we'll claim it. And as the Commission also said, let's hope this sends a signal, particularly to dealerships in the case of complainants being women, that, you
can't
think
get away
twice
with
about just
budging it.
blaming the woman's lack of driving skill for the problem.
Absolutely. Thank you so much for that. Wendy Knowler, we'll chat again next week, Wednesday. Just a reminder, if you do want to bring a case to Wendy's attention, her email address is consumer@knowler.co.za, spelled KNOWLER.